This is Attorney Doug Jones. Welcome to Elder Law in 5 minutes or so. We're going to be talking today about trust funding is important, putting stuff in the box. And we're going to be using the example of the box as an analogy to the trust. Obviously, a trust is not a wooden box. It's a bunch of paper, hopefully with the right kind of words on it. But we're going to be referring to that. And when we first create a trust, think of it as an empty box with nothing in it. So I dumped all the stuff out of the box and now it's empty. And that's like your trust when you first set it up. It has nothing in it. And some people I've seen make the mistake over the years. They set the trust up, they sign it at the lawyer's office, and then they don't put stuff in it. Putting stuff in it is called funding the trust. And that's very important because if you haven't retitled your assets to your trust, well, it controls what's in it, which is nothing at first. So funding is critical. After the trust is set up, well, then the trustee is the one that controls it, and you're the trustee probably. In most cases, you're the trustee of your own trust. And then, of course, once you die or are incapacitated, if your trust discusses incapacity, which most of them do, well, then whoever you have set up as trustee controls the trust. They're the successor trustee along with whatever is in the trust. And just to give you an idea of how that works, let's say you and husband and wife own a checking account. So we'll call them Bob and Mary Brown. Bob and Mary have been married for years, and their checking account is Bob and Mary Brown, and that's what's on the checking account. So that's in their personal names. And if they died, both of them died with that account as is, it would probably have to go to probate before it passed on down to their intended beneficiaries. But what if they set up a revocable living trust and they want to put that checking account in trust? What would they do? They would title the checking account to the Bob and Mary Brown Living Trust. They would deliver probably a certificate of trust to the bank, and that would put the account in trust to make sure it's retitled in the name of the trust, the name of their trust, and the bank or the financial institution receives the certificate of trust. What about other things like 401ks or life insurance or IRAs? There's some things like that you don't title in the name of the trust directly. In IRAs, an individual retirement account, it has to be in your personal name. But when you die or are incapacitated, then it can pass to the trust by virtue of a beneficiary designation. Now, before you do that, you would want to definitely check with your attorney, your CPA, or your financial advisor to see if that's a good idea. Sometimes it's not. Sometimes it's a better ideal to have maybe your beneficiary would be your spouse, and maybe the contingent beneficiary would be your kids or whoever you wanted it to go to. Sometimes there's tax reasons for it not to flow directly into the trust. So you would need to definitely check with your attorney, financial advisor, CPA, or all three to make sure that the trust was funded properly and you put the right assets over in the trust and you didn't put the assets in the trust that didn't need to be there. Sometimes people want to leave one account outside trust. So let's say Bob and Mary put all of their assets in the box. They had their attorney prepare a deed titling their home over to the trust and their rent house over to trust and their interest in a farm over to trust and everything in there, but they had one checking account that they didn't want to put in the trust. This checking account was Bob and Mary's secondary checking account, and they had their daughter Betsy on there as also a signer. Well, Betsy can't be on that account if it's in trust because who are the trustees of the trust? Bill and Mary, that's it. They're the only two that can sign on it. If they want Betsy also to be able to sign on the account, she would have to be one of the primary trustees of the trust, and she can be if they want that. Or they can just leave one account outside of trust. They can just have one checking account outside of trust with mom and dad and daughter owning this one checking account. just know that this account is not in the trust. It wouldn't be controlled by the terms of the trust because it's not in it. So some people do that just for convenience, just leave one account outside of trust. As you're meeting with your attorney, it's a good idea to think about all of your financial resources in advance, what accounts you've got, where they're at, and have a discussion. How should these accounts be titled? Which ones should be in trust? Which ones should not be in trust? What do we want? Do we want maybe one account to be left out of trust? Make a list so you don't miss anything. What you don't want to happen is this, to forget an account. They had maybe a brokerage account and they just forgot it. And so they didn't title it over to trust. And so it's just a floater out here. And when they died, then it wouldn't be in the name of the trust. It wouldn't be have a daughter's name on it. It's just in their name, and they died and it stuck. And so it'd go through probate. You don't want that. Usually that's not the reason they do the trust. They want to avoid probate. So you want to effectively retitle everything, and sometimes this takes a few weeks to get all of this done. The key is to be very persistent. You may call your broker, the different financial companies, you may send them letters, but be persistent until you get verification that the accounts that you want titled to trust have in fact been retitled to trust in trust. And again, what if you forget something? They had that one account they just forgot, or this one piece of property in another state that they forgot to title to trust. You may also have a document called a pour over will, P-O-U-R, pour over will, that when you die, the pour over will says, okay, we forgot this, we're going to take this thing and put it in a trust. But the way you put it in trust, it can't just go over there directly. It's got to go through probate, and then once it goes through the probate process, then it can go into trust. But probate can be expensive, time consuming, and if they would have just titled that account to trust while they were living, they could have avoided probate on that asset. But we do a pour over will as a safety net, just in case they forget something. A lot of times they put everything in trust while they were living, but later on in life, they get another asset, another piece of property, another bank account or brokerage account or whatever, and they just simply forget to title it to trust, and it's just sitting out here floating. That may have to go through probate. So make sure you get all of your assets that you want in trust there to start with, and then later on in life that you also put any newly acquired assets over there. So that's a lot. Funding's a big deal. Make sure you make a list of everything, have that discussion with your attorney, financial advisor, and CPA, and get it all done right. Thanks for watching. If you're watching this on YouTube, please hit the subscribe button and notification bell so you can be notified of any other videos that we do. And leave us a comment. We'd love to hear what you think. Appreciate you watching today. Have a great day.